joining this webinar, which we've titled the Compliance Labyrinth, Finding Your Way in Contentious Insolvency. I'm Rachel McCahill, Associate Director at Manolete Partners. That's me on the screen. You have me twice now, aren't you lucky? Joining me is Alison Morgan, who will just say a few words about herself. Anyway, just a couple of housekeeping points. We've got a really good list of attendees today. We've got lawyers, IPs, we've got somebody, at least one person, I think, from one of the regulators. We're more than happy to answer questions. We will either do them kind of at the time that they get raised, if that's appropriate, or leave them until the end of the session. If you put a message in the chat box, everybody will see that that message is from you. So if you would rather keep your query anonymous, then I've put in the chat my phone number and my email address. So if you want to drop me a line separately, I'll keep an eye on that, and then we can deal with those questions on an anonymous basis, if that makes people feel more comfortable. So just moving on to introduce Ali, somebody that I have known for a long time. Ali, would you like to introduce yourself?
Yeah, morning. Thanks, Rachel. And morning, everybody. Thank you very much to Manolete for having me. Thank you as well to Amber in the background, who's helping with tech stuff because she's not very well. So I really appreciate the invite and the opportunity to speak to everybody. As Rachel said, we've got a really great audience today, which I'm really thrilled about. It's a while since I've done this, so please be kind to me. And I can't multitask, so I'm relying on Rachel looking at the chat box in case there's questions. Thank you very much.
Okay, so the way that Ali and I have structured this webinar is to obviously talk about kind of, compliance issues, both, I guess, from a legal kind of perspective and, a compliance perspective more from the regulatory side of things. And the way that we've tried to structure it is almost to try and work through a case kind of in chronological order. So hopefully that will make sense. But as I say, chat box is there. I've got my eye on my phone as well. So first question really to kick this off, for me to ask Ali, why is compliance important in contentious insolvency?
Thanks, Rach. I will just thank everybody for joining again, because whenever I mention the word contentious, quite often I get people rubbing their eyes at me. For me, it's always been about doing the job right. And the fact that there's so many people on this call, I think today just emphasises what we all know, is that we're all trying to do our very best and a good job, often in very difficult circumstances. I think, to put it another way, many of the people on this call do know me from my prior backgrounds, both at the regulator and as an IP before setting up my own business. But many people know that I follow quite a bit of sport, and I quite like using sporting analogies. If people will humour me at this point, when I sit watching Leicester Tigers with my husband, I quite often say that if we've got really good discipline in the match, it won't necessarily win that game. But if the Tigers' discipline is really poor, we can absolutely lose it. And I think that's absolutely the same when it comes to insolvency. Doing the job right is great, might not win loads of work necessarily, but if we get it wrong, the consequences can be quite severe. And I see firms take it really seriously. There's lots of firms I know that spend a lot of time internally reporting, looking at various statistics. Lots of firms have systems that will tell them if there are particular tasks that are upcoming, for example, and even if they look like they're overdue. So I do know that the profession and the IPs want to get it right. I also hear they get quite frustrated when month on month those internal reports don't seem to show any improvement in their own compliance. And sometimes it is just a housekeeping matter because things have been done but not marked off. I know that our profession doesn't always get good publicity, attracts quite a lot of negativity a lot of the time, and certainly where things go wrong, it doesn't help. So I also think it's really important on a wider scale, not just for the consequences on us as IPs individually, but also for the whole profession. And ultimately, when it comes down to investigations, and claims, as we're talking about today, regardless of the regulatory requirements or otherwise, there are potential assets out there to recover for the benefit of creditors, and dare I say it, for our fees. And I have said it, I do say it, we're not a charity. I say that a lot. But for those that like hearing the authorities, just as a bit of a non-exhaustive summary, we've got the company's directors disqualification legislation, we've got statements of insolvency practice 2, and there's other specific legislative sections that vary depending on the geographical regime in which we're operating. A lot of people here today will deal with England and Wales cases, but of course there's also Scotland and Northern Ireland, and there are some differences between them. Some people might be surprised that I will mention SIP 4 more than once today. Those that even remember it will know it's about 10 years since that was absorbed into SIP 2, but for various reasons I will also mention that former authority. Which sort of brings me on now, Rach, to ask, and you said we'd sort of go through the chronology of a case. The starting point for me is always the books and records. So just how important is that from your perspective?
I think, well, books and records is a topic that we're going to spend quite a lot of time on today under various kind of different headings. But the books and records are effectively the company's evidence. They're crucial for helping to work out what claims there are, what the prospects of success are, whether you've got a good claim, actually, whether there are rationale there to explain why directors might have taken certain actions. Management accounts, for example, will assist in working out net deficiencies, an early state of solvency. Board minutes or a lack of board minutes will speak to the intent of the parties, whether decisions were considered, discussed, whether correct procedures were followed, for various decisions. And there might be other evidence relevant to the claims, contained within the books and records as well. If there aren't any books and records, or they're incomplete, then that itself may speak to a breach of duty by the directors. And actually, the whole question of whether or not there aren't any books and records, whether there are some books and records they're incomplete, or whether they haven't been delivered up, again, is something that we'll kind of chat through during the webinar. Have you got anything to add? For particular question I always seem to come across is there a difference between not collecting books and records because there aren't any books and records, or because there aren't enough funds in the estate to kind of do more than the initial kind of have you got any books and records, that initial obvious collection?
Yeah, thanks. And I think that's a really good summary. And before I delve into the answer to the question that you've asked, I'd like to start by saying I do hear of some people quite scared about all things data or books and records. Gone are the days when IPs now will schlep to a premises and there's stacks and stacks of boxes and they have a third-party agent collects them and puts them in a warehouse and provides an inventory, which all seemed quite straightforward, although sometimes had some pitfalls. But things have obviously moved on. We've got hard copy records, soft copy records, things all over the place. And I sometimes hear people either say, it's not my job, we've got a team that deals with that, or they don't really know what they're doing. And for me, it comes back to the starting points of what the procedures and the policies that we have are, because if that's clear and understood, it can absolutely mitigate some of that fear. I also think some of it comes from when things have gone wrong. So maybe the collection hasn't been done appropriately, and then it's made lives really difficult during the job to actually do it and or respond to appropriate questions that we're asked. And I think that just exacerbates people's fear because of previous experience. And just to give a bit of context, if anybody else looks at the sanctions that are publicised by the Insolvency Service, as I do, not least for learning points, when I last looked a while back, it went up to kind of October last year, and in the first 9 or so months of 2025, of the 30 sanctions that were published by all the recognised professional bodies, 7 of them actually mentioned deficiencies in investigation work, including not collecting the records, which obviously raises the flag, oh, I've got to collect them. Of course, you can't collect what you don't have. But again, just to tie in here with the authorities, SIP 2 paragraph 19 says the submission of conduct reports is one of the statutory duties that automatically fall upon the office holder. and as such must be complied with, notwithstanding any shortage of funds. And then back up the SIP at paragraph 9 under the initial assessment heading, it says notwithstanding any shortage of funds, an office holder should consider the information acquired in the course of appraising and realising the business and assets of the company. It goes on to say the office holder should make inquiries of the directors and senior employees by sending questionnaires or interviewing them. So we've got two actual different paragraphs there mentioning notwithstanding the lack of funds, and I think the profession's quite clear. Obviously we can't collect what's not there, and I have seen case files that will evidence the questions asked, any site visits done, and document the answers to those questions. I personally wouldn't necessarily rely on the answers coming from the mouths of potential delinquent directors against whom I may seek to bring claims. If they tell me there aren't any books and records at all, I'd be a little bit cynical about that and might want to try and make some other enquiries. I'd certainly want somebody at least to go to the premises in most cases, if not all, whether that be your agent or you. Again, I think times have moved on since we automatically all went on site all the time. But I think it's wise perhaps to have somebody have a look at what's there. So I think it's clear that lack of funds isn't an issue, but I have seen IPs come up against brick walls and asked time and time again of the director, please can we have the books and records? Oh, we haven't got any. Please can we have the books and records? Oh, we haven't got any. And as I've alluded to, it can help to perhaps go a different way around. Are there people in a tech department that might say, well, we've got a great big server here with a backup? Or is there somebody in an HR department or personnel that says, well, yeah, of course we keep books and records and they're here? Is there something in the creditor list that suggests records may be stored elsewhere? And of course, ultimately, we do have statutory powers to use. I have heard the regulatory bodies say they expect IPs to use those, and ultimately, why wouldn't you want to use them? There may be instances why that's not reasonable in the circumstances. And again, that then comes down to documenting your rationale as to what you did and or didn't do and why you didn't do it, because ultimately a decision not to do something is still a decision. So I've referenced there as well, documenting various things and having the strategy at the outset. I do see lots of IPs ask questions early on that may then subsequently help them during the course of the job, which is an effective way of doing it, of course, and you're more likely to get the engagement early on probably than at any other time. Some IPs, for example, routinely ask for reports of aged creditor analyses if the insolvent entity systems allow that. And interestingly, and I did promise I would mention this, so I am going to mention SIP 4 again, even though we no longer have it. But SIP 4 at paragraph 16 specifically asked for aged creditor analyses to be appended to any adverse conduct report that an IP submitted. And I do still see IPs wanting that. I've also seen some who've done graphs. I'm not the most techie of people, but I'm getting better at it. And I've seen graphs that really clearly show and demonstrate where the position may have worsened, if at all, or if not, which can be really helpful. There's also some situations I've seen where IPs have made a decision to leave the records with a third party, and that quite often arises where there's been a business sale, for example, and there are, and I would expect to see clauses in a sale purchase agreement to deal with that, to make sure that the IP has the access that they require. And the best in class files will also evidence still what the records were that the company had, where they are now, where they're being kept, in what format, the access rights, and some comfort over the security of them and what the third party is going to do with them and when. I wouldn't want to hear of a third party that said, oh, well, I just destroyed these because I didn't know how to keep them. So that can be important, getting the clauses right in that SPA. Similarly, in MVLs, quite often I see IPs maybe under pressure to leave the records with the entity, particularly in groups. They might be commingled with other entities, and that can similarly happen in insolvencies where not all of the group is insolvent, but the records are intermingled. So again, it will come back to that documentation of what you decided to do and why or why not. Many on the call who deal with MVLs will have probably had some sleepless nights when the Noel case came out, and I think we're all grateful to the regulators for their narrative and very pragmatic approach on that, but not forgetting we do still have MVLs that convert to CVL, and therefore what you document at the start of a MVL about where the records are, etc., may be absolutely critical if it then converts and you do need to start your investigation work. So I've always been a big advocate of the clear documentation. I think it's also worth bearing in mind, though, that books and records aren't the only intel we might have. There are other sources of information. Right from before we accept a job, we may have seen, heard something. Clearly, third parties might share some intelligence with us. I see some firms doing social media account searches on people, and that sometimes flagged some assets that weren't disclosed. It's amazing how often people love to post all over social media, look at my brand new car, but then when asked what assets have you got, oh, I haven't got anything. So that can be quite helpful. We also have things like the deficiency account in CVLs. Again, this is one where I've sometimes had IPs roll their eye at me. So why do we do it? We have to do it, and we produce one, but what's the point? And I found they can be quite helpful in what they tell us. It's not always the case when the books and records are very poor, but that estimated deficiency in the period can be quite telling. And if we're asking ourselves, what does that mean in the context of what the entity did, it can be quite interesting. And I'm sure many of you will know there are two different ways to reconcile the deficiency count, and I've seen more than I want to see that were done incorrectly. So it misses that opportunity of intelligence. If you haven't seen it and you are able to access it because of who your regulator is, the ICAW has an absolutely superb pro forma for deficiency count preparations on its website. It is pretty foolproof, really easy to complete, and does it by both methods as a sense check that the figure produced is correct. So I really recommend that. But I had an example where the deficiency account had been incorrectly reconciled and suggested hardly any loss in the period at all. But when done correctly, the loss was about £1 million in a 10-month period. And when I thought about it and put my head on of, well, this was a non-trading holding company, how on earth has it lost £1 million in 10 months? Could there be misappropriation? Has there been a theft here? And started to explore with the IP. Actually, that holding company itself had always been charged with 100 grand a month of management fees into group. So it absolutely made sense. And we could conclude that perhaps it wasn't telling us anything that merited further investigation, but that opportunity had been lost because it hadn't been correctly reconciled in the first place. And I have seen some IPs do deficiency accounts even when it's not a CVL and not required, because they do see the merits of it. Obviously, most directors do want to do the right thing, and we know that our initial investigation is based on what comes to light during the course of the job. But I think our profession's always been one that's been badged as cynics, and probably appropriately so, because that element of professional cynicism can be really helpful. It's certainly stood me well, and the best that I've seen will always question again if the answer isn't answering the question, go round it a different way if possible, but then step back and think, what does the answer tell us? I have seen answers to questions posed to directors that simply did not make sense when thinking about what the business did. The answer just couldn't have been true, but the IP had taken the answer and gone tick, yes, got the answer. And there we go. And as I've mentioned, people do get fined for it. So really important that, notwithstanding the fees in the job, we are absolutely getting that right at the start. It will certainly help going down the line.
Yeah.
Which, go on, Rach.
Sorry, I thought you'd finished.
I was going to ask you the next question, but carry on.
Sorry. No, well, I'm just picking up on a couple of things that you've said. But there's been a bit of, when you're talking about, think about who you ask information from in terms of kind of books and records. That seems to be a bit of a theme at the moment, because certainly in the courts, in relation to witness statements that that insolvency practitioners may make once a claim actually goes to court, they're saying, well, actually, if it wasn't the insolvency practitioner that did the investigations, is it right that it's the insolvency practitioner that makes the witness statement? Actually, should it be somebody more junior within the firm who makes the witness statement? Whereas, you know, when we were kind of working through, nobody other than, it would never have even been considered that anybody other than the IP would be the person making a witness statement. And if he'd have said to me at 2 years qualified, you've got to make a witness statement, I'd probably cried. Coming on to your comment about the age creditor reports, that's really important information for us when we're looking at whether or not to buy a claim, because it, as I said earlier, it speaks to early state of insolvency, it speaks to, you know, conduct, it can assist with preference claims, all of that kind of thing. So actually the age creditor report, I think, is a really, really crucial piece of information. And then just what you were saying about social media, I think it was Martine McCutcheon, when she was bankrupt the first time, she was pictured in one of the magazines on an outing somewhere with an incredibly expensive Hermes handbag, which was then kind of snaffled back by the trustees, because obviously you and I, Ali, would say that an Hermes bag is absolutely something that is a necessity, but funnily enough, the trustees in bankruptcy felt that it was an item of excess value, and so they snaffled it. So social media and those things are really important. And I remember a bankruptcy I was dealing with where I was actually acting for the bankrupts, where they agreed with the trustee to put the property on the market, and it was a property worth about £2.5 million, and they'd said, but we don't have any assets. But of course, if you're selling a property £2.5 million, in the old days, you got a really nice big glossy kind of sales brochure which had lots of silverware on the dining room table, huge 4-poster, but all of that kind of stuff that actually is are items of excess value when you're not living in a £2.5 million house. Insurance policies as well, kind of again on the more personal kind of on the contentious side, I guess in terms of books and records on the personal side, insurance policies, and again for companies, because quite often items over a certain value will have to be specifically kind of referenced in the insurance. Right, so coming back to the slides, what actually constitutes the books and records of a company?
Yeah, it's a good question. When I first was talking about this with you, I thought, gosh, it seems like a really noddy question, because on the face of it, it should be quite straightforward. But actually, it's something that I've spoken with a number of IPs about. And when I went digging to think, well, let's go back to the authority, what have we got that tells us what the books and records are? I couldn't actually find a single statutory reference for it. So I did, having done some training, so I'm doing my hands up here, I did use AI and asked it for a definition of books and records, and it came back with what it said was a practical legal definition commonly used by courts and regulators, which says that in the UK legal and regulatory practice, the company books and records mean all accounting records, statutory registers, and supporting documents that a company is required to keep in order to evidence its transactions, financial position, ownership, management, and compliance with legal and tax obligations. And we've heard within that, the first bit was the accounting records. And there are some statutory provisions in Companies Act legislation, certainly, that reference a company keeping adequate accounting records that are sufficient to, for example, show and explain the company's transactions, record the sums of money received and expended, include statements of stock if applicable, and there's others. And then similarly, there's statutory provisions about the statutory registers, or statutory books as they may be called. And that includes, again, for example, the register of members, of directors, the register of people with significant control. And then there's also some record keeping obligations set out in the legislation. So all of that in the round can help us then understand what we mean by the books and records. And it's pretty wide. Some would say arguably anything other than a marketing flyer could constitute books and records, which then comes down to, well, what do we have to do as IPs to collect them? And again, we've got authorities in SIP 2 that we know relates to admins and insolvent liquidations. And at paragraph 5, it says the office holder should locate the company's books and records in whatever form and ensure that they are secured and listed as appropriate, which we've alluded to already today. I've also found, and some on this call today might not be familiar with it because it's 13 years old now, but I've found Technical Bulletin 104 issued by R3 from June 13 really helpful. Now, I looked at the R3 website a week ago and it does say it's under review. Perhaps not a surprise given it's so aged. So the R3 website says not to rely on that technical bulletin as an up-to-date reference, but I do still think it contains some helpful narrative. It's also got some really helpful guidance on retention periods for different types of books and records. They're not all subject to the 6 or 7 years retention with which we may be familiar. There are certain documents that are subject to longer retention periods by law. So I still think that's really helpful, and I hope to see that retained in there. So that's perhaps a useful one for people to look at if they're not familiar with it. I would add that, and I mentioned this earlier, and maybe going back some time when we used to just trot out to a company premises, sweep up all the boxes, stick them in storage, have an inventory, put it on the file, do our investigation, and then destroy them a year after dissolution of the entity. But some other entities, believe it or not, are not great at storing records and destruction of them either. And you can end up with absolutely masses of records that there's no obligation to keep. And I think it's really important that IPs consider what they do collect very robustly at the outset. It's costly to store records, and I personally wouldn't deem it fair and reasonable for an estate to pay to store records that we could have left or could have destroyed. So I think that's one to think about, and I do see more and more firms now revisiting their strategy on books and records collection and the destruction and when. We don't necessarily have to wait till the end of a job, but ultimately if the estate can't bear the cost, somebody's paying to store them, and it's probably hitting your P&L. I think there's also, yeah.
Sorry to interrupt. It's just that there's been a couple of questions on this, which I think I don't want to interrupt your flow, but they're probably relevant to ask them now. So someone's asked, what about National Archive requests for documents? What about collection of emails, or requests from researchers and universities? My son is a historian.
Yeah, the National. I'll take the National Archives one first, because I have seen that happen on a few instances. For those that haven't seen it, some IPs do get requests from the National Archives in respect of books and records over entities that may be deemed of interest to society. It's probably not the absolute correct terminology.
So if the Natural History Museum were to go bust, then that would be an example of something that might be, potentially,
but also companies that may have got a really long history, established 1901, operated for all these years and then went bust. Whether they may be of interest now, somebody might think, well, in another 100 years' time, the history of that entity and what happened to it could be, like Lehman's potentially, is that of interest to people, what happened to it? And so they're getting requests. And there was some narrative, certainly from at least one of the regulatory bodies, about cooperating with and assisting with such requests. And of course, we shouldn't ever ignore any question we get or request, really. But I'm not going to say one way or the other here, because IPs also have a duty to think about the creditors generally. And I have had some IPs say to me, this could take me hours and hours and hours on an ongoing basis to deal with. And is there any benefit to creditors? Is that really in my duty as office holder? So I certainly wouldn't ignore those questions, whomever they're from, but we ultimately have to bear in mind our duties to the creditors. I'm not aware of any statutory requirement to provide records to National Archive, etc. So IPs are looking at that on a case-by-case basis. I've not seen many such requests. I've only seen about 3.
Would it be reasonable for the IP to say in a request for that, well, we can do it, but you're going to have to pay our costs of doing it, because it's not in the interest of creditors for the creditors to incur that cost?
Yeah, and it's a good point, and I've absolutely heard IPs moot that. The main concern I get from IPs, other than, although it's a crucial one, data protection consequences, because ultimately once you've handed something over, you may or may not have lost some control over that, and you might have concerns about the personal and or sensitive data that may be contained within it, and segregating those records could be very time consuming and costly to no benefit to the estate. I have heard IPs moot whether they can seek the cost of it, but then how does that escalate? And one of the concerns I've heard is it going to be so straightforward as saying, here are the records? Or are they then going to come back to me and say, thanks very much, we now have this question, or we want to know about this or that? And they're worried that they will not then be able to put a lid on where the costs go. So I'm not here giving an answer yes or no to anybody. I'm just flagging some of what I've seen and some of the considerations that IPs are having to take.
Yeah. And the other question was the collection of emails.
Yeah, again, going back to what constitutes books and records, anything that would be something that can evidence the transactions of a business, money's in and out, and they could be an email. It's a common form of communication now. Firms may say invoices automatically by email, etc. It's certainly something to think about and inquire. And not to be dismissed. There could be some really useful correspondence on email for investigations, I would suggest. Some people put too much down in writing, arguably. Our own profession has also been guilty of that in the past. So there could be some really useful snippets in there from an investigation angle, even if strictly it doesn't fall within the definitions I've just outlined of what books and records are. It could nevertheless be helpful intelligence. So we shouldn't be ignoring that. But also, and coming back to where we left off with the slide and what we collect, and this sort of ties in with your email point, the more we collect, the more cost it's going to have. And there's also potentially the indirect cost of that. So I have heard of firms that have uncovered that they've still got some records they thought had been destroyed, or they realised they could have destroyed them and they haven't, and they've now got a data subject access request and are having to think what they do about that, because they haven't actually destroyed the records, so they can't legitimately turn around and say, I haven't got them, sorry. So what do they do with that? So there's also indirect costs of keeping and storing stuff for too long. I am absolutely not encouraging people to go and just destroy records willy-nilly without having considered what they are, the right retention periods. And there might be instances where actually whatever we thought at the start changes through the case. So we might end up faced with some litigation either against the entity, or indeed that we've uncovered we want to bring, and we might need to keep some records longer than we initially thought. I've also had some IPs sort of just chat with me generally, again, not coming to any conclusions necessarily, but their thoughts about what they would do if they were appointed over a company in a sector, particularly if it's in a group, given the recent legislation that could result in building liability orders on the solvent associates, and what their thoughts would be about records that they should keep and for how long, given the look back period in that legislation is about 30 years. So would it be frowned upon by an associate if the IP had destroyed something that could help the associate defend a claim, when we all know what the legislation says? Don't know, one to watch. But again, the top tip, I guess, is the clear strategy at the outset, and the best in class always keep that up to date and reviewed and looked at. And if I was a betting person, I'd say SIP 2 will probably be updated, not least because of where we're going with technology. You mentioned emails, there's other things. I think you've got a case on WhatsApp.
Yeah, and it's interesting because we've literally just had a comment, businesses are using WhatsApp more and more in business. How easy is it to collect a full record? And I've been banging on for a while about how I think that WhatsApp is actually quite an important method of communication. I think it's surpassed text messaging. For a lot of people, it's surpassed email. Lots of people now have one phone rather than a separate personal phone and a business phone. So, and you can actually have, you could actually have, you know, customers, suppliers or whatever that are also friends as well. So there might even be within one particular message chain, you know, business conversations and personal conversations. And there has been a recent case which I find interesting in relation to WhatsApp. Now it's in a bankruptcy context, but I think it's relevant. So it's the case of Reed Goodmanson, and in this case, husband and wife married in 2009, had 2 children. They then separated in 2016. Divorce petition presented in October 2017, and then there were financial remedy proceedings commenced under the Matrimonial Causes Act. After the financial remedy proceedings were commenced, husband and wife had discussions in December 2018 about kind of, you know, trying to reach an agreement. And these discussions included an exchange of emails and also an exchange of WhatsApp messages on the 3rd of October, in which the husband suggested that the wife take on responsibility for caring for the children 100% of the time. And in return for that, he would transfer his share of the family home over to her, because he wasn't going to be living in, you know, in the same town anymore. What then happened was bankruptcy order was made in February 2020 against the husband, and the family court judgment was handed down on the 4th of March. Now, as is quite often the case when you have kind of financial remedy proceedings and bankruptcy orders, the family court doesn't actually find out about the bankruptcy order until kind of, you know, quite late on. So the trustees applied for possession and sale of the property. The wife defended that application, one ground being that the husband had effectively transferred his interest in the property to her because of these WhatsApp messages, and therefore there wasn't, you know, the bankrupt didn't effectively own any beneficial interest in that property. Now, what's relevant here is kind of the purposes of this webinar, and I guess the wide question about WhatsApp is the question, you know, had he actually transferred his interest in the property? Now, what was interesting was, so this case went up to the Court of Appeal, but the court at first instance held that the relevant formalities for disposing of an interest in property are governed by Section 53 of the Law of Property Act 1925, which basically says, in order to have a disposition of an equitable interest, the disposition has to be in writing, and it has to be signed by the person who's giving that property away, or by, you know, some kind of lawful agent. Now, what the court of first instance said was that the WhatsApp messages and emails evidenced a clear intention on the part of the husband to release his share of the property to the wife, as the WhatsApp messages satisfied the conditions that the communications were in writing. So historically, I guess we would think writing is actually, you know, wet ink on a piece of paper, but of course, you know, not many people deal with things in that way anymore. And then in relation to the requirement about the document being signed, although the WhatsApp messages didn't conclude with the husband's name, his name was on the header to the messages, and that identified him as the sender and authenticated the messages as coming from him. And the judge held that his name was intended to confirm that the message came from him, and so it therefore satisfied the signing requirement under the Law of Property Act. Now, a quirk of this case was that the wife didn't win on that particular point, but only because in financial remedy proceedings, they can only be concluded by an order of the court. And this was an agreement between husband and wife. You know, it wasn't ratified by the court. But it creates a clear kind of interesting legal question as to where WhatsApp fits into this whole issue of communication, contracts, intention. So it went up to the Court of Appeal. Now, the Court of Appeal held that the WhatsApp messages didn't transfer beneficial ownership. But the rationales for that, I think, are quite interesting. So the first was that the parties were negotiating their financial settlement, and they'd both got solicitors instructed. So presumably the Court of Appeal felt was that if there had been an agreement reached, it would have been, it would have been through the solicitors would have dealt with it, or they would then have communicated to the solicitors that they had reached a deal. Then the court said, considering the WhatsApp messages and emails comprising the 2018 communications in their context, I have come to the firm view that they do not demonstrate him evidencing an intention at any point to unequivocally and immediately relinquish his interest in the property. To the extent that the deputy judge found otherwise, I consider that he was wrong to do so. However, what is interesting is what the Court of Appeal said next, which is it might be technically possible for a WhatsApp message to have the requisite intent and satisfy the requirements of Section 53 of the Law of Property Act. Normally, you wouldn't expect the use of a medium such as WhatsApp to kind of deal with such a valuable asset, but it has highlighted that the Court of Appeal can see circumstances in which WhatsApp would be, the use of WhatsApp would be sufficient to, conclude a contract. So if we're getting to the point in law where WhatsApp could effectively, or the communications on WhatsApp could conclude a legal contract, then applying that in a books and records context, I think WhatsApp, is something that needs to be considered. Now, the difficulty is, of course, with that is, if they're all on a person's individual phone and they're encrypted, how do you get them all? How do you know when you've got them all? And is it even appropriate to ask if the director's phone is a personal one? We could probably do a whole session on that, and I am conscious of time, but I think the relevance of that case is WhatsApp needs to be something that people are thinking about in terms of books and records collection. Even if you think about it and you disregard it, coming back to your point from earlier, if you document your reasons for it, at least there's a rationale behind it. And certainly from a court's perspective, they don't normally interfere in the commercial decision of an IP, provided that it's not an IP that it's not a decision that's just an off the wall decision that nobody else would make. So it comes back to your point, even a decision not to do something is still a decision. But I do think WhatsApp, and then other electronic methods of communication are something that the law will have to catch up with, and it seems to be doing so actually relatively quickly in the grand scheme of kind of legal precedents. So I think it's something that we really do need to to bear in mind.
So we've talked about what the books and records are, duties to collect them, but of course we've said all along we can't collect what categorically doesn't exist. And you did mention right back at the beginning that a lack of records itself could be a breach by a director, but what more would you say in terms of potential actions and recoveries when there aren't any records?
So there's an issue, and it's important to distinguish, is whether there aren't any books and records because they just don't exist, or there are books and records, some of which or none of which have been collected in by the IP, and what the reasons are, for that non-collection. So just to kind of illustrate this, there's a lot of case law on this, but I've picked out a few cases just to talk about quickly that kind of highlight the impact of that. So recent case of Brown versus Bashir. This was a case where it was alleged that the directors had diverted money away from the company and kind of underdeclared in their VAT returns. In that case, the directors totally failed to cooperate in producing the company's books and records, which of course then made assessing what the losses were difficult. And what the court in that case said was that if the lack of cooperation persisted, the court basically might be forced to fall back on revenues figures as being the best available evidence in order to assess the losses. In the per point case, there was again a total failure to ensure that proper books and records were kept, and so there was a recreation of cash flow records, cash flow calculations, net worth calculations, in order to ascertain the extent to which the company's net liabilities had increased by the continuation of trading. So in that case, basically the court imposed its own calculation. Very recently, there's been the case of Kay and others versus Vision Payroll, where
Oh, have we lost?
Away from the... Yeah, I'm back.
Are you
Am I
back? We just
Yeah.
lost you when you started to talk about K, I think.
Yeah, sorry. So in K and others versus Vision payroll, the court ordered equitable compensation by reconstitution in relation to monies that had been been diverted away from the company, subject to receipts back in that could actually be evidenced. And what the court said is that missing records provide no shelter for directors. Now, so that's quite clear. The court's view is if there aren't any books and records, then the court will apply some kind of a calculation. However, if you look at the Robin Hood case, which is a wrongful trading case, in that case, limited books and records were collected at the outset. And the liquidator apparently expressed surprise at the time, given the type of business it was, as to how few books and records there were. Now, the court's position was that if there were further records, because it came to light later on that there were further records, that the directors have a duty to advise the liquidator of the fact that there are additional books and records that haven't been collected. But equally, the liquidator hadn't followed up with correspondence or oral requests asking for further books and records, or for an explanation as to why there weren't the level of books and records that the liquidator would have expected to have. And in addition, computer hard drives were held to be relevant in this case, but they weren't searched until very late in the day, and therefore the court refused to admit them into evidence. So there's a clear difference in terms of books and records, you know, in terms of bringing claims. If there aren't any books and records, it's easier to, I suppose, you know, come up with your own calculation. I mean, obviously there's still got to be some science and justification behind it, but you're pushing slightly more on an open door compared to where the, you know, where there have been some books and records and you haven't collected them. And because, as you've said, IPs have a duty to do that, you know, the court may not be too impressed, and that may actually make, you know, your claim slightly more difficult to bring. And yeah. Alan, yes, I will send out those case references afterwards. Just a quick question.
And I have heard some IPs now are actually categorically asking directors to confirm that they've delivered up everything in terms of books and records. I'm not necessarily saying that we shouldn't have our cynical head on if they say there aren't any and I've delivered everything, when we might be ringing claims, but some are asking for that. And the theme throughout has always been, we've mentioned a few times about the IP's own records, but we've largely been talking a lot about the company's books and records. So flipping now absolutely to our own records, what comments have you got about the importance of those?
So record taking by IPs and staff is incredibly important. You know, lawyers tend to have a mantra: if it's not written down, it didn't happen. And when I was training and first qualified, my supervisor spent just as long training me on drafting a good attendance note, reviewing it, amending it. You know, drafts would go backwards and forwards, as he would do with anything else that I drafted. And to me, that speaks to the importance of attendance notes. You know, it's that contemporaneous record of what was said, discussed, you know, what advice was given. And then, you know, in terms of bringing a claim, record taking by IPs is incredibly important. You know, I kind of spoke to members of the team at Manolete about this, and you know, we frequently see defences such as the company wasn't really insolvent, it could have traded out of its difficulties, but the IP pressured me into putting the company into an insolvency process. The IP didn't warn me properly. He was aware that I was going to repay myself money, or, you know, the IP advised me to recategorise, you know, dividend payments as salary. So obviously, recording what discussions and what advice is given is important, you know, to kind of rebut those frequent defences that we see. Also, proceedings can take a long time to get to a hearing, so they're relevant for, you know, for memory, that kind of thing. We also find that they're really helpful where there's a long gap between the first consultation with the IP and the eventual appointment. What advice did the IP give? You know, did the IP flag up the risk of wrongful trading that the directors then ignored? You know, all that kind of thing. And the other importance about kind of record taking is would somebody else easily be able to establish what advice has been given by the IP in their firm? You know, can somebody easily see what your thought process was? And also something that people don't often think about is if you're not taking notes or making a record, but say the director is, well, if somebody's got a contemporaneous note and you haven't, then the contemporaneous note is probably going to carry more weight as to what was discussed. And in theme with, you know, how we've dealt with this so far, I have a couple of cases just to kind of, you know, bring it to life. So the first one is a case called Bass versus Buchanan. So in this case, director paid herself minimal salary of £6,000 a year. And then since 2007, she had withdrawn another £3,000 a month by way of a director's loan account. Company got into difficulties, wasn't able to kind of, you know, write the loan off by declaring a dividend. Director went to her husband, who was a solicitor, who went to see insolvency practitioners and sent a memo to the insolvency practitioner saying the balance sheet shows a director's loan account has been in existence since 2007 and currently has a balance of £201,562. So I bet husband was really popular at that point. What was then alleged was that in December 2014, the director's husband met the IP at the Ivy, and that during that meeting, the husband claimed that he was advised by the IP that the company should identify the DLA funds as drawings rather than loans because of the minimal salary that she'd been drawing so far. And apparently then the director then instructed the bookkeeper to do that. Proceedings subsequently issued in relation to the overdrawn director's loan account. Now, by the time proceedings were issued, the IP was retired and was no longer a joint liquidator, but still gave evidence. And whilst there were no notes of the meeting, he said that he would never have advised a director to reclassify the DLA as drawings. He'd been in IP for over 40 years, would never have done it. And also there was no mention of that being advice kind of in the emails that passed between the parties subsequently. And the court accepted that he hadn't given advice to reclassify the DLA kind of at the Ivy meeting. So the other thing that flags up as well is records of decisions don't necessarily have to be in an attendance note. They just have to be somewhere. So obviously in the absence of a note at the meeting, they looked to the emails as being the only other contemporaneous kind of evidence at the time, and there was no reference in there to that advice. Now, flipping that on its head, we have the recent decision of Manolete versus Trevor Howarth, which we lost. So in this situation, the company went into a trading CVA in February 2019.
And we lost Rachel again.
Am I back again? So I don't know why that keeps happening. Sorry.
No.
Yeah. Okay. So Mr. Howarth was the sole shareholder, was also heavily involved in the business, but as part of kind of the refinancing and, you know, getting the company back on its feet, he ceased taking his £200,000 a year salary and instead received equivalent monthly payments drawn down against the director's loan account owed to him. And he withdrew a total of £101,000 in that way. CVA failed, and then the company went into administration. Now, what happened was the original administrator died and a successor practitioner was appointed. Claims sold to us and proceedings were brought for the sum of £101,000, you know, which was drawn down by him against his director's loan account. And it was argued that it was inherently unlikely that a licensed insolvency practitioner would have advised the director to put such an arrangement in place, given the terms of the CVA and the duties that were owed to creditors. However, the director defended the claim, saying that the director's loan was at way more. It was at £97,000 plus interest at the time of the CVA. The arrangement was made on the advice of the IP, as the purpose was to save the company large sums in PAYE and national insurance that otherwise would have been payable on his salary. So he was saying by doing that, I was actually saving the company money. And then importantly, he relied on contemporaneous notes of a meeting in December 2018, which were prepared by the firm's finance director, which which recorded the fact that the loan was not included, paid instead of payroll. And in the absence of any notes by the IP to the contrary, and then the fact that the IP involved in it had actually died, creates a slightly more difficult position. And the judge found that on the evidence, the judge was satisfied that the advice from the IP was that this salary loan swap arrangement had to be put in place in order to save PAYE and national insurance, which it would otherwise have to pay. So, quite an important decision. I'm just conscious of time. So what about from a compliance perspective, Ali?
Yeah, thanks, Rach. And we've mentioned a few SIPs. I'm hoping it's clear to people about the importance of the record taking. So what I'm going to limit it to saying is I hear a lot of IPs and staff saying, I just don't have the time to make all these file notes as things happen. And I always intend to catch up later. And we've moved on from the days when I trained, when IPs used to walk around with dictaphones in the hand, constantly recording something that was then printed and put on the file. It didn't negate the need to read it. I have seen one file note that also regurgitated an IP's road rage because he was dictating it whilst driving. So I always think there's merit in reviewing anything that's automatically produced. But we do have Teams, for example, that records automation, phones, and the time spent after the event, if you haven't done a contemporaneous time note and you haven't done a contemporaneous note and you've got a complaint or something, far outweighs the benefit. So however you do it, be it a voice note on your phone at the time or something else, or if you know you're not the best at it, get somebody else to help you. And similarly with emails going on files, I hear of lots of IPs spending hours before a case review to get them on the file when there's functionality that allows that to happen if it's set up right in the first instance. So get somebody to do it. But I've mentioned all the SIPs before, other than one that's also obsolete. And it's just as a tip, because SIP 12 used to be about meeting minutes. I think what it set out is really helpful in your file notes. I remember the mnemonic I came up with in my JB studies over 25 years ago without even going back to my notes. But there are some tips, and I see too many file notes that don't even include the basics of who was discussing what, when, or even dated at the time of doing it rather than the time something happened. So actually, I think that's a helpful one, even though we no longer have it.
Yeah.
AI.
Yeah, good old AI. So has AI and all the sophisticated software that's now available altered the expectation of the level of initial investigations?
I'm going to say no on the basis that the SIPs and the guidance say what they say. For me, it's more about how we do it, how effective it is, how accurate it is. Humans being humans, and I've done it myself. I've misread something, overlooked it by mistake, and we have software tools available now to analyze bank statements very quickly, very accurately. Why would we not take advantage of that? If we could, I'd be loath to be the IP, and I have seen it where something's been mistakenly read, names on a transaction were very similar to one another, and an opportunity to make further inquiries has been missed. So I think it's one that is really going to be helpful to us, and those IPs that aren't already using it probably need to catch up a bit, I would say. I don't know if you've got anything to add, or if you want to just cover the last few slides.
I will just mention quickly, because I think it's more relevant probably than one of the other slides, is that there's a lot of play at the moment about AI. It will kind of transform the legal world. Obviously it will do in certain circumstances, but there are there's been that big case where a legal precedent was relied on, and it turned out that AI had just kind of made it up. If anyone was at the SPG conference a couple of years ago, there was a really good session on that, and I think AI can tell you stuff and it can give you the results, but you still need to have that detailed understanding of what those results actually tell you and how that can then be applied. So I suppose my worry with AI is that it will reduce people's skill sets in that area because we'll rely on it too much, and actually there's still an element of thinking that only we are going to be able to do. Yeah. we've run over now, so apologies everybody. I think the questions we've got left is a challenge of appointment. What should IPs do to protect claim value? I think this is probably the more important one to deal with.
The other one, just take it seriously and don't ignore it.
Yes, yeah. Okay, so so let's just talk quickly about what IPs do to protect claim value.
Yeah, so, well, carry on.
Yeah, sorry. So I think from my perspective, it's progress matters without undue delay. Lots of reasons we've already talked about. Memories can fade, documentation can go missing. One thing that I've seen quite a bit since joining Manolete is keep an eye on the income and assets of targets and their values, because you can have a really good claim and have a really bad target, or the other way round. So it's quite common for checks to be carried out towards the beginning of a case as to the financial viability of a potential target, but then that position's never checked again. And we see cases come to us where it's considered that the target has assets, but actually when we carry out searches later on, those assets may have been sold, which renders recoverability an issue when it wouldn't have been, if the matter had been kind of passed to us earlier. Equally, we've seen cases the other way round, where people's financial positions have improved, and so a claim that wasn't necessarily worth pursuing at the start of an insolvency may actually become a more attractive claim a bit later on. I'll always remember a bankruptcy case I dealt with years ago where the bankrupt inherited an unencumbered property on day 363 of her bankruptcy. And she was such a cooperative bankrupt, even the IP felt sorry for her. But these things do happen, people do inherit. We recently did a webinar on limitation, so that's not an issue. You can access that. But the other thing just to flag up is lashes, if I've pronounced that properly. So that is a defence that can be brought by a defendant, even if a claim is brought within a relevant limitation period, where they can allege that the person bringing the claim has effectively, fallen asleep on the job. They haven't progressed things in a proper way, in a timely fashion, and as a consequence of that the defendant's position has changed, and that's something that we do look at Manolete when we're considering whether or not to take on a claim. Not only is a claim within limitation, but also whether there is any potential issue in relation to lashes. So if you've got a claim that you flag up with somebody on month 6 of an insolvency, and then you're totally radio silent on it for 5 years, yes, you might still be within the limitation period, but there might be a risk that this defence of lashes gets raised. And there is case law around it being accepted as a defence. And then I think just the last one to cover off, given the time, is we've chatted about this, Ali, but we do see IPs identifying claims after vacation of office or a company's been dissolved, and we see it more than you'd think. So a classic example is where you have causes of action that weren't particularly well known that then become more well known. Bounce back loan misuse is a classic one. Insolvency right at the beginning, coming out of the pandemic, the cases might have been closed down quite quickly because it wasn't really thought that this was a potential claim, but actually then it becomes a potential claim. We see cases where a cause of action was identified, and at the time it was thought the target wasn't worth anything, but then subsequently it turns out that they are. So if you've identified a claim for whatever reason after you've vacated office, or after you've vacated office and the company has been dissolved, applications can be made to restore the company to the register. We deal with quite a few of these situations. So from our perspective, there are 2 main issues. One is from restoration, kind of the limitation period is it doesn't stop. So limitation may be a lot closer than you think if a company's been dissolved for a year. And so action may need to be taken quite quickly. But then obviously from an IP's perspective, having the money to make the applications referred to can also be an issue. We will look at cases before applications are made and make offers, obviously, if we think there are, if we think there is a claim, on the basis that we will carry through with that offer if the company, if the IP gets the company restored. So whilst the IP might need to front end those costs, they do so knowing that they've got an offer, and what the initial consideration will be, which hopefully then can, refill that gap where the IP's had to front load those costs. And we've done that quite a few times.
Yeah. So any final top tips?
From my perspective, start books and records as soon as possible. Document, your decisions and your rationale, even if it's just sending an email to somebody saying, following our discussion, here's a bullet note of what we discussed. Go back and check, targets, their financial worth, keep that under review, keep limitation and lashes, in your mind. Obviously think about litigation funding. And what about from you?
Our work's not a silo, so all the intel right from the start could be really helpful. So make sure you can gather that in from your colleagues. Use your statutory powers if and when you have to. File notes, however you get something down, do it. And also something you alluded to earlier with witness statements and who's appropriate. It's important to recognise who's tasked with doing the investigation work and their expertise and understanding. And I regularly hear IPs say that they didn't get what they expected from their colleagues, and there'll be reasons why that. But exploring and making sure people fully understand is really critical. And I would suggest just saying, do you understand, won't get you a helpful answer. There's ways to make sure our colleagues do know what they're doing, because it's so important. But thank you, everybody. I appreciate we've overrun. I hope people have taken some tips away from that.
I don't know if anybody does have any questions. Mark Darby's asked a question. Mark, I'll have a chat with Ali about that question, and we'll get back to you unless you want to stay on the line.
I can stay on. Thank you for your thanks. Thanks, Alison. Good to see you on.
And just again, thank you everybody for for attending. There will be another webinar soon. But as I always say, if anyone does have any topics that they think would be useful for us to cover, please drop me a line and let me know.